Right. Well, thank you everyone for attending the 10th episode of our webcast series, Affluence to Wealth. My name is Sarman. I'll be the co-host along with my business partner, Ara Sahakyan. So I'm really excited for today for a few reasons. Number one is, as Ara said, our 10th episode milestone. Number two is that this is our first in-person recording of our webcast, which is nice post-COVID. But most importantly, number three is we have two very special guests with us, Lori Stein and Caroline Wang. How's it going, guys?
Great, nice to see you. Yeah.
Ara?
Very well.
Awesome. That's great. So a fun fact about both Lori and Caroline, which I don't know if they know about each other, is they both were called to the Ontario Bar in 2002 in the same year. Yeah. Meaning both of them have over 20 years of experience. So yeah, they're both very knowledgeable, very accomplished, and have been very instrumental in helping PGate get to where it is now. Lori is a partner at McCarthy Tetrault, and she specializes in securities regulation. She was very, very influential in helping us regulate or get registered as the Exempt Market Dealer, which we'll talk about later. Caroline Wang is a partner and founder at Wang Legal, and she specializes in corporate and commercial and any transactional deals. So, sorry. So both ladies here are very, very influential in their respective industries and have really helped PGate get to where it is right now. So thank you both for being here. So what we'll do is we'll have a typical Q&A, and then we'll open it up to anyone here for any questions later. So why don't I just start off with a very simple question. Why did both of you get into law and your respective specializations?
All right, my story is a little bit boring, but I'm a third generation lawyer. I think it was in my DNA to become a lawyer. My grandfather put himself through law school in Montreal, and then my father and my uncles, like there are many lawyers in our family. So I actually wanted to be anything but a lawyer growing up.
Right.
Like it was off my radar. I saw how hard my dad worked, but going through undergrad, I just kept gravitating towards those courses and just ended up in law school. And as it turns out, I really love the practice of law. I'm one of those lawyers that actually enjoys getting into the technical, regulation. I find it very intellectually stimulating, and the most fun thing is working with entrepreneurs that are trying to do something new and innovative, and I've been fortunate enough in my practice to be really focused on that, so it's very rejuvenating, so I don't get bored.
Right. Interesting. Caroline?
So for me, I just kind of stumbled into it, truthfully. I did an undergraduate degree in business at Schulich, and towards the end of my degree, I thought, oh, what am I going to do? There's all these options. I'll just go to law school. So I ended up going to law school thinking that I could change the world, and realizing that changing the world doesn't really pay the bills. So I fell back into corporate, and articled that the big firms really loved working on these transactions, complex deals, and just figuring out solutions. And as my practice evolved, it became more about strategizing with the client and not strictly about the law says this. It's how it applies to my client's business and how it can help them further their business. So I much enjoy my practice now than when I first started.
So, and if I may add, so we went through a selection process for selecting both Lori and Caroline, and they were by far our top choices. With Lori, she really understood our business. So we had gone to this playbook, copy and paste company that was, much cheaper than what Lori was at Osler at the time. And no, it wasn't. I'm not saying she was expensive at all. I'm just saying.
I gave him a really good deal. He negotiated with me, and I gave him a really good deal.
You're a lawyer, right? Yeah. So, but the difference was she understood what we're trying to do. And that made such a difference when we got registered as an EMD. It was a fairly painless process. It was a process. But because she, in our compliance manual, for example, it reflected exactly what we're doing, which is different than a fund, which is different than a typical EMD. And I think that's what made us successful. So thank you, Lori, for that. And she's very bright, and so is Caroline as well. And with Caroline, she's our transactional lawyer, so she also understands that we don't have a very long time frame, and we don't have a huge budget, because our transactions, as you saw from the slideshow, they're typically under $1 million or around $1 million. So, but we use the same level of detail and professionalism as a $50 million deal. And Caroline always reminds me, it doesn't matter the size of the deal, it's still the same process. So they've been both, so I thank you both for being part of TDA as well. So.
Speaking of speed, I think, so the deal we're looking at right now has a 30-day closing time frame, so Caroline, thank you for that.
It's less than 30 days now.
Yeah, it is, yeah, time is ticking. Okay, so we'll just jump into Exempt Market Dealer, which I touched on earlier. So what is an Exempt Market Dealer, and what role does OSC have in regulating PGATE's activities as an EMD?
Sure. So an exempt market dealer is really a dealer, so an intermediary that helps investors find investment opportunities and helps raise capital for businesses, that does that only in the exempt market. So as opposed to the public markets where you have prospectus qualified securities and mutual funds that are ready for investment by retail, if you want to be that kind of dealer, you have to become a member of CIRO, and it's like a much more prescriptive, rigorous form of registration, because you're dealing with retail investors and you're holding shares in CDS. The exempt market dealer is a much more flexible registration category that is designed for a whole range of business models, but the real purpose of it, and I think it's different in Canada than in the US, they don't have this in the US, is that the Canadian regulators are of the view that even in the private markets, investors, even if they're accredited investors, still need some level of protection. The intermediary needs to do a suitability analysis. They can't just say, oh, if you've got the money and you qualify as an accredited investor, go ahead, go blow your brains out. They have to gather information and make sure that the investment is suitable. And our regulators have sort of rolled this out, and at first it wasn't clear when it wouldn't apply, but over the years, the regulators have really expanded the scope of what it views as exempt market dealer. So by the time ARA developed his business model for PEGate, it was pretty clear that the type of business that you do would be regulated.
It was, and she scared me into it, but as a lawyer should. But it is something we really need, because that also means we can market our deals publicly. Well, we haven't, because we've closed 5 deals, and we've actually been oversubscribed on each deal. And with suitability, funny enough, one of our guests, he couldn't make it today. We actually turned him down because it wasn't suitable for him. He was building a house and it was going to be a tight investment. So we actually said, this is not a suitable investment. We'll wait. So that it is regulated, but it's really protecting the investor. That's the main goal, right? Of the OSC.
And along with protecting the investor, as we were just talking about before, the OSC is very focused on conflicts of interest. So because a lot of exempt market dealers are also involved in the investment itself, there's also a requirement for the dealer / kind of enterprise to give disclosure to the investors about those relationships and the fees that are being charged, so that the investors really understand what the deal structure is. And when you're outside of the regulatory framework, there is no oversight to make sure that the disclosures that the investors are receiving are adequate.
And are the typical exempt market dealers, are they selling somebody else's product, or how many are like us?
In my experience, there are many that are like you. One of the examples of an industry where exempt market dealer has become very popular is not just popular but required, is mortgage investment managers. Like, that whole industry didn't used to be regulated. You could go out and raise private capital to invest in private mortgages, and it ended up being quite a risky area. And over the years, all of those mortgage investment managers have had to become registered, so they're selling their own products, and similar things with some private debt funds. So any business where you're in the market all the time raising capital for your business, it's likely that you're going to have to get registered. There are also those that really have an intermediary type of business, and they're not clearly connected to one related issuer or group, but I would say, given the total number of exempt market dealers, more likely than not, more exempt market dealers are related to the products that they're selling.
Interesting. And I'm seeing it a lot with art, right? They're doing fractional ownership, they're doing it for real estate as well, so it's I think it's important. And shadow banking was a big thing, of course, right? Where there's a lot of second mortgages that are not under the purview of banks, and how do regulators see that, right? So, yeah, regulation, in conclusion, is good for the investors, and thank you for making us an exempt market dealer. Caroline, this is for you. What is your typical involvement in deals? Why is it important to have a good lawyer on your side?
It's always good to have a lawyer on your side. My involvement varies from client to client. In the case of P-Gate, this is a very sophisticated client. They've done many deals, they're very well versed, so they've usually already embarked on quite in-depth financial diligence and other diligence on behalf of their targets. I usually get involved either at the LOI stage, the letter of intent stage, or a bit after. Again, because P-Gate is so well versed in investigating all of their target portfolios, you know, it's more often than not that I am at the LOI stage. And it is really important to have a lawyer early on to make sure that the pathway from beginning to end of your transaction, there's no hidden hiccups along the way. After that, it's the diligence phase, and then we go into definitive documentation, and then the actual closing itself. So if you can get your lawyers involved at an earlier stage, you might be able to prevent some hiccups that can be costly both on a time and money perspective later on down the road.
Yeah, agreed. So before a deal, we typically talk to our lawyers, and I don't know if John's in the room, our auditor at Siegel, and just to make sure we're on the right path, if it's an asset sale or a share purchase. So it is important to get them involved early on.
Awesome. And so can you give us some examples of how investor interests are protected and what type of documentation, legal documentation used to do so?
I mean, at the first stage, when you're looking at the LOI, you want to make sure that it's a non-binding LOI, unless there is a specific reason that you want to get that binding and have that other party committed. Through the diligence stage, it's very important. So by way of an example, P-Gate was looking at a target entity. We ran some basic security searches, and it turned out the seller had a CRA lien on his assets. Now, if anyone knows what the CRA does, at that point, if they're liening and publicly registering a lien on your assets, you know that that seller is very well behind on paying their taxes. And the CRA have a super lien, so that means that you acquire those assets from the debtor, you acquire it subject to that lien. So at the end of the day, CRA doesn't care who owns the assets. If they're going to realize on those assets, whether you're the buyer or the person that actually owned it, you're going to be on the hook. And so that was just one thing that came up early on in the process before Ara and his team invested a lot of money into the deal. We backed away from it. Yeah. And that was the right thing to do. And it protected your investors, protected his credibility, and mitigated risk.
That's right, and a similar deal where for some reason, the advisor disclosed in writing that they take cash payments and not declare, which was pretty shocking. Yeah, so a lot of people do that. Yes, Michael knows that deal well. And then so again, even though they would stop doing it, like, you know, once we invest, everything has to be above board. But we just didn't want to have anything to do with such a business, so we walked away early on before investing.
Yeah, it's important to know, like, even though you've expended money into a potential deal, it's okay to walk away from that deal if it's a bad deal, right? That money, I look at it like it's insurance. Nobody likes paying the premiums, but oh my gosh, are you really happy when that insurance policy is in place if you need it? Right. So I think that's like a key takeaway is that if you know it's a bad deal, don't be afraid to walk away from that bad deal.
I remember there was a deal Ara was chasing for, I think it's been 2 years. 3 years, and he's been talking about it for a long time. And when I joined, we started the due diligence process, and we were pretty deep in. And we just, as much as we hated saying we have to walk away, because all the time and effort we put in, it's better to pull the plug and have to deal with all the problems down the
So
road.
this was some of you know this, because some of you had committed to it.
Yeah.
It was the cranes on top of buildings. And it was a week from close, and we actually fronted them.
Anyways, yeah, we were in the parking lot, we're like, Caroline, sorry. And,
Yeah, and it was near closing, right?
We had advanced pretty far down the path.
Yeah, and then we were paying for those fees, so, and it was like Caroline said, that's a sunk cost. And then we pulled out because there was one electrician that was kind of blackmailing us during the last interview, saying, well, once we close, we'll have a talk about my pay. And then we knew he was kind of protecting his job by not doing everything at a high standard.
to code.
Yeah, so I got a call a month ago. And so we ended up, which we're proud of, we supported management to buy them out. So although we pulled out, we told management, listen, you're gonna be the only option here for the sellers. We'll back you, and we did, to buy them out, because otherwise the business is gonna close, you're gonna lose your job. And so they're very grateful, and so he called me a month ago and saying, about that electrician, you're absolutely right. We just had to fire him, and it's gonna cost us a lot of money to refurbish those units, so yeah.
So what would you say are some of the key characteristics of a successful shareholders agreement or SP?
The shareholders agreement there's two levels, right? There's at the acquisition co-level, through which most of these investors will invest through, and then there's also, in some cases, with the portfolio company itself. From, I guess, the acquisition co, the investor co-level, you want to make sure that the shareholders agreement has some minority protection rights, and that the manager is treating the shareholders in a fair manner from an investor perspective. You'll want to make sure that there's some oversight in terms of how decisions are being made, and some involvement from the shareholders, and some information rights that are given to those investors. Similarly, that would filter down through to the portfolio companies as well. I know that in our shareholders agreements with some of the partners, it's very collaborative, because it is important, because it's not just paper, it's a relationship, right? The paper does reflect the relationship, but it's important that it be fair, balanced, and that everyone feels that their interests are being protected in a fair manner.
Awesome. I have one last question for you before we jump into more regulation. What are some common mistakes investors should avoid?
I think the most important thing is not knowing who you're doing business with. This is not a legal issue. You could have the best paper in the world, but if the person who you're doing business with doesn't have that character to hold up and stand behind their word, you've got bigger issues than the paper itself. So I think it's important for investors to diligence who they're doing business with, take a look at their reputation, look at their track record, ask around, find out what they've done, because that's going to go further than just paper that doesn't make sense to a lot of people,
Right.
truthfully, for the layperson.
Interesting. Okay, Laurie, OSC. So actually, for those who don't know, I used to be a trader. So I have done several exams with the OSC. And OSC is always looking to protect investors and is always, of course, staying up to date with different trends. So what are some of the new trends or new updates to the OSC's Ontario Securities Commission that investors should be aware of? So any trends that you're seeing?
Well, the OSC sort of publishes an annual report and a statement of priorities every year where they outline what their priorities are and then all of the great things that they've done over the years. So just thinking about the most recent one, and there's been a real focus, as I mentioned earlier, on conflicts of interest, and the feeling of the regulator is that industry is not providing adequate information to investors. Investors don't really understand the conflicts, and so there was a series of amendments to the registration rules that took effect in stages over the past couple of years, really designed to improve information about conflicts, but also take the position that there are some kinds of conflicts that if they can't be resolved in the best interest of the client, like that's the standard, you just cannot, they're not acceptable. So it used to be that you could kind of disclose away every conflict, but now that the rules have changed to say every conflict must be resolved in the best interest of the client, the expectation of the regulator is that some things you're just going to say no, like it's not going to work, we're not going to do that. So that's been a big focus. The area that I practice in, so I'm sort of skewed in this direction, I'm really focused on fintech, and that's one, the PE Gate platform that you probably all interact with is really quite sophisticated. A lot of it is online, you're interacting electronically, there's electronic data management, there's personal information. The regulator, and that's not just PE Gate, really the whole new generation, everything new that's coming out right now, all the new products is all technology driven. So yeah, and that's really where I've been focusing, and it's a very fun area to practice in, and it's because the regulator is conservative and their initial reaction is discomfort. If there's not an actual person that's reviewing everything at the end of the day, like, we have a problem, the technology is going to make mistakes, and like the regulator really wants to be sure that ultimately there are people that are accountable for everything. But all that being said, the proliferation of technology and the very, very good things it can do and the way that it can make things more efficient and more uniform and save time so that you can do other things like look for the next deal, none of that can be ignored. And so the big focus of the OSC has been sort of promoting innovation and encouraging responsible use of technology and figuring out what are the right guardrails to put in place for registered firms so that they can use technology, but ultimately the people that run that business and that are responsible for making investment decisions are ultimately accountable. And not surprisingly, everybody's talking about AI these days, and of course AI could be a very helpful tool for portfolio construction, suitability analysis, all kinds of things. But if consumers or investors are given access to AI tools and have the sense that those AI tools can replace an advisor, the regulator is very concerned about those risks. And it sort of relatedly, if you think about the meme stocks and GameStop and all of those, unregulated, unregistered communities that are developing online and kind of encouraging this very risky behavior. It's often called the gamification of investing, platforms like Robinhood that really make it feel, especially for like the younger generation, that you're playing a game when you're making investment decisions. The regulator's very focused on all of that and trying to figure out how to address the investor protection risks associated with that without just trying to prohibit it, because they know that if you just say it's not allowed, that's what investors want. They're going to seek it out anyway, and then they're just going to end up using unregulated. They're going to go offshore. They're going to do more dangerous things. So that, I think, is a real focus of the regulator.
Interesting. What do you think some challenges they might face? Like you said, I think they're deep fakes, right? AI. There's so many ways that it's catching. Who comes first? Yeah,
so I mean, the issue is that the regulator does have a lot of tools that it uses to surveil the market. So a few years ago, the OSC actually established a separate branch that's like data and technology management within the OSC, because they have all these tools that they use to sort of look at the internet, look at Twitter, look at sort of keywords that are going out that are suggesting potentially, problematic activity. And of course they rely heavily on complaints. So when they get a lot of people call in, they complain, then the regulator uses that information to then go out and do more research. So those are the tools that the regulator has. So there's no way that they're going to catch all the bad actors. They simply can't. So what they try to do is a lot of education and outreach as well. If the OSC launched a website a few years ago called GetSmarterAboutMoney.ca, and really encouraging people to do searches. Is this advisor registered? Is this business that you're thinking about investing in, like transferring money to, are they registered? They have all these investor watch lists where they identify, because I mean, on the internet, like anybody can create a fake website and market some ridiculous investment opportunity, and it's actually shocking how many people fall for these scams. Right. But when it comes to deep fakes and stuff, there's only so much that the regulator can do, and even only so much that the registered firms can do. The reality is that people will take steps no matter how many times they've been warned, and they'll figure out a way to transfer that money to that shady offshore platform, even if they've been alert, and the banks, when you go to transfer money out of your bank account to something weird, the banks have their own amazing systems, and they'll say, are you sure you know what that address is? And these fraudsters actually coach these targets in how to convince the bank to let them move their money. And it's really shocking how many people sort of fall for this. I do a lot of work now in digital assets, aka crypto. So this is extremely prevalent in the crypto industry, as I'm sure it doesn't surprise any of you. And I'm sure that all of you guys who are investing with Ara, I'm sure you're not touching crypto. But you can, the more things are online and the less there are humans involved, the more these risks proliferate.
Interesting. So when you got registered, actually, we're interviewed by the OSC, and it was early on, and we decided, thanks to Lori's advice, that we could have gone one, I think, fintech path that they were starting out.
Oh, the launch pad.
Yeah, the launch pad, or what we did. So we went with what we did. It was just me, so I'm everything: the CEO, CFO, compliance officer. But it was the technology that I think, because we were using technology, that I think that gave them comfort. Would you say that had an impact on the registration?
Well, we did a demonstration of the platform, and that's what the regulator wants, a full walkthrough. They want to understand what the client experience is. What's the client going to see? What information are you going to be providing? And how are you safeguarding the client information and protecting the client? So we went in there and we did a demo. I remember still the room, but you really instilled confidence, and part of that is because you're an accountant and you clearly had a lot of experience, and everybody at the OSC is either a lawyer or an accountant. I would say there's more accountants than lawyers, but when they see those letters, it does give them this kind of degree of comfort. And so I think that there was a combination, and you were also just great in that interview, but you can see, I've been to many of these interviews, and they've gone in different directions, and you have to be confident without being arrogant. If you're too timid, that's a red flag, and if you're too brash, that's also a red flag. So it's getting to that perfect balance and giving the regulator that level of comfort that you've got integrity.
Yeah, and we didn't have to go through another process, which is great. And that was a third-party platform we've used, so now we've developed our own. So we do have a dev team in Armenia, actually, that handles it. So, and there's a two-way communication now. Before it was just one way, us communicating to the investor. So now I think it's much better, but we had to get our security levels up. So it's been and we had to disclose that to the OSC. So in our compliance manual, there is annual reporting. We have to report on technology, what we're using, what's the security. So this is an ongoing process that we have to go through. So I thanked a lot of people. I forgot to thank my wife, Tamara. Right? She's part of the team too. And I also want to thank people who drove from afar. So John actually came from Napanee, but the furthest is the person next to you who came from Dubai. Dubai, Italy, London, and Toronto.
Yeah, and Phil from Ottawa.
Oh, Phil from Ottawa. That's right. Sorry, Phil. That's
yeah. But yeah, no, jumping back into regulation, I think the reason why OSC really liked it is because all the data is housed online in the platform where we could provide them a login, and they get to see all the transactions, the communication, and it's all stored there, right? It's not like we're just sending them attachments on emails. We're saying it's all there, whether it's suitability tests, KYC, all their legal, the documentation, the reports, all the history is there, which I think they love.
And that's why we don't attach documents, or when you get an email, it's in the platform. So to keep things confidential, we're not attaching documents into the email. It stays in the platform.
I think there's an added level of confidence with the transparency that you guys have shown with USC, right?
Yeah.
By allowing them access.
Yeah. Okay, jumping back into due diligence, red flags, deal breakers. Can you please outline PE Gate's due diligence process?
Okay, so as Caroline said, it's generally early on, and we do follow that. If we can't work, if we don't like the people we're going to work with, we walk away regularly. So I think the first time I met with John and Bill, and there's a trust factor. There's, John's motto is really health and safety for his business, so taking care of his people. And Bill, it's all about quality, and so these are things that that's the first part of the due diligence. Can we work with these partners, because we see it as a long-term relationship. With Lucy, for example, with the pets, she sold 100%, and she's like, I'm out, but Sarman's talking to her every day.
She can't let go. She's amazing.
She's amazing. Right?
Yeah, it's her baby. She's built it over 15 years, and I guess she really loves it. That's the thing. It was a passion project. It wasn't just to make money. She's passionate about it, and she's passionate about taking care of her legacy and all the staff there, right? So she helps a lot still, way past the transition period. So yeah.
So that's the first level. Like, are they good people? And then we look at the numbers. So the transaction has to make sense. So we don't like to overpay. That's our policy. Do not overpay. And we start looking at, are there any red flags? So we analyze the P&L. But as an accountant, that's something if you've been through audit, the balance sheet is more. John's here. He's going to get excited by this comment. So our auditor. So I look at the balance sheet. Like, a lot of people just, let me look at the profit and loss statement. But if the balance sheet is off, the profit and loss is going to be off. So I review the balance sheet first. So that's just as important, because one of the first fraud investigations I did at PwC, the owners were like, the owner was like, oh, every year it's showing profit. I don't get it. But every year they asked me to inject more money into it. So we just looked at the work in progress, and it was just increasing. So the losses were being hidden in the WIP. Simple as that. He didn't look at it. So looking at the numbers in detail, and then we look at, is this business have a future, right? So we look at the business model. So even before the numbers, does this business have a future? So those are the three main. You guys, would you add anything to that in terms of what you've seen things go wrong?
Well, then you've got to give it to Carolyn so she can do the legal due diligence,
Right.
on all the searches and go through the agreements.
Yeah, but that comes after, because really before the legal diligence comes into play is whether or not financially it makes sense. So you have to go through all the financial diligence, the people diligence first. We're a little bit further down the line, because at that point, you like the people, you like the business, it makes economic sense. All right, let's move this forward and get this closer towards closing.
And that's a good thing, having a good relationship. Caroline knows exactly where we stand on things. So with Bill's transaction, I think we had so little involvement in terms of, Caroline, here are the 5 things, go for it. And it was really easy for us. I think Bill, it was more challenging. Bill, how was your experience with your lawyers on the transaction?
Well, it was a little bit more complicated, because we added shares to a couple of employees, and so there were other lawyers that had to look at their particular, do their due diligence, and then we had to wrap it together with our due diligence. And of course, it was the first, it was a unique situation, because the architectural firm selling to a third party that is not an architect underneath the Architects Act, third parties that can only own a max of 49% of an architectural corporation. So there were those aspects to work through from our point of view, your point of view so that we were understanding completely what we were both getting into.
It was a complicated, so that 51% did complicate.
Yeah. Have you seen any deal breakers from a regulatory perspective? You know, people trying to get involved, they're not regulated. Is there anything?
I mean, for sure, and when Carolyn's point is well taken, which is that generally speaking, by the time the lawyers get involved, the business loves the deal. And so that's why it makes it more difficult for people to accept that they need to walk away because of a legal issue. But when we're dealing with regulated entities, there's a whole regulatory approval process before the transaction can go ahead. So I'm talking about like when the entity itself is regulated. Like for example, if PEGate wanted to bring in an investor that was going to end up owning 10% or more of the company, that transaction would need to be pre-approved by the regulator before you can even close. So that's an area where I get involved a lot.
Right.
And it's usually, you know, in the purchase agreement, regulatory approval is a closing condition, and it's usually the thing that is holding up the deal. So, so there's a lot of kind of pressure to push, and regulators work from 9 to 5, and it's very difficult to get them to move quickly. One of the things that I think I bring to my clients is that I have, because I do regulatory work pretty much exclusively, I know a lot of people inside the regulator, and I can like place a call, get somebody going a little bit, and so that's very important in terms of moving things forward.
Right, yeah. I can imagine that probably holds up deals quite a lot.
Yeah, and like you can imagine with large deals that involve financial firms that are regulated in multiple jurisdictions, they can sometimes trigger, 10 different regulatory approvals globally, and you have all these, and I've seen a lot of situations. I was just involved in one where there's an attempt to structure a deal to avoid, that tripping up that 10% ownership change so that you don't have the regulatory approval. One of the other issues around the 10% trigger is that if you become a 10% shareholder, you also need to make all kinds of disclosures to the regulator, because the regulator, it's not, what you were talking about, the Architects Act, it's not that dissimilar. Like the regulator wants to know that this person has integrity if they're going to be, a significant shareholder of a registrant. I guess in the architecture industry, you want to make sure that it's actually the architects that are running these businesses and making the decisions. So I've seen proposals where an investor gets non-voting shares that convert at certain, on certain triggers to avoid having to go through that process. And then it always is like, well, what are you so afraid of? Like, why can't you just fill out that form? And when you file the form, there's a criminal record check. And so it's a little bit of a red flag when somebody is so reluctant to go on their radar screen, but people also have very good reasons, and there's privacy concerns, and especially for people that are outside of the jurisdiction, they're like, why do I have to share this information in Ontario? It really goes back to the first point, which is it's about the people, and there really is a gut instinct of whether or not you trust somebody from the beginning, and then you can work with them on these more technical points.
And how would you say, you brought up the one with Ontario, so I believe the way it still works, it's Ontario versus rest of Canada, is that
Well, the way that it works with securities regulators, and it's never going to change. So I was told by one of my mentors when I was a junior securities lawyer, and I got involved in an initiative to create a national regulator. I remember I was sitting in her office, this was in the late 90s, and I told her what I was doing, and she pulled out these magazine boxes with these old, from 1982, books that had been published about a proposal that she had worked on in 1982 to try to have a national securities regulator. And she's like, every securities lawyer gets involved in one of these at some point in their career. You're going to learn something, but it's never going to happen because of regionalism, because Quebec will never let it happen, Alberta will never let it happen, BC will never let it happen. So the answer is, but what they have done, what the regulators have done, is that they've really tried to harmonize the regime. They work together a lot on all aspects of the securities regulatory framework, so registration, but also the issuer side, so that if you're an issuer raising securities, if you're a registrant, you're dealing with one regulator, your principal regulator, and then that all the regulators have jurisdiction, but they generally kind of trust, and the degree of trust is different depending on the regulators. Ontario, there's a system across Canada except for Ontario called Passport, where it really is a true passport. So if Quebec approves an issuer, or Quebec approves a registrant, that approval is good enough for BC, it's good enough for Alberta, not good enough for Ontario. Ontario always keeps this kind of like reserve power to review everything, and they say that it's because their legislation doesn't allow them to delegate, but it's really because they don't really trust all of the other regulators. They like to keep everybody in line. But the day-to-day experience is generally that you're dealing with your regulator, and then if another regulator has a concern, they'll filter it through your principal regulator. But like, you do have to actually maintain a separate registration in every province where you have clients, and you coming with the registration, there's also fees. So it ends up, there's sort of like every province is like, you want to get registered here, this is how much it is for the firm, this is how much it is for the individual. So it can really add up, and that's something that often shocks clients that are coming from a different jurisdiction where it's not like that. But
Like the US.
yeah.
And the US is because we looked into it, so once we expand to the US, it's not as stringent as Ontario for what we're doing, for what we understand.
That's right. Like in the U.S., there isn't like a private, a dealer category that's specific to the private markets, and the threshold for triggering the requirement to register as a broker dealer is quite a bit higher. Like the activities that you're currently doing, you have to comply with all the private placement rules there, and there are filings that need to be done, but it's all on the relating to the securities as opposed to the dealing activities.
So we have a question.
I'm surprised by that. And what about these US that come up to play in the Ontario market? And then their rules they don't really realize.
So that's a very good question, and there is a regime in Canada for firms that are based outside of Canada and are registered outside of Canada, that they are permitted to do some activities in Canada in reliance on an exemption from registration, and that exemption is called the International Dealer Exemption and or the International Advisor Exemption, and there's also one for fund managers. But when you rely on that exemption, you do have to make filings with the regulator, you do have to pay fees, but you also are restricted. You're only allowed to deal with permitted clients, which is a higher level than accredited investors. It's basically institutions and ultra high net worth individuals, which means $5 million plus in financial assets, which excludes real estate. So that part of the market has access to these international firms that have a very light regulatory touch, and the reason for that is because the regulator, generally speaking, those types of investors are considered to have their own, in-house expertise in making those investment decisions. And what they do is they actually waive the suitability obligation. So we talked about suitability being a core part of what you do. If you're an accredited investor, you're actually not allowed to waive suitability. It's only available as an option for a permitted client.
And I do recall, I believe it was last year, they expanded the scope of accredited investors from only a certain threshold of money to whether you have designations, if you're a CFA, CPA, because it's not as accurate to say those with more capital are more educated and more suitable for investment. So that was quite interesting.
They have. I mean, I think that they've proposed. I don't think that those changes to the accredited investor definition have been adopted yet, but I think that they've been proposed.
Right.
And that's consistent with the regime in the UK. They really look at sort of your financial literacy and your background, and that does make sense because especially for people who maybe are self-employed or have assets but don't fall within one of those accredited investor boxes, they're trying to figure out ways to expand that a little bit.
So that was actually perfect because I wanted to jump into Q&A and open it up to anyone. So if anyone has any questions, feel free to raise your hand.
There's a few lawyers in the room too, so feel free
Let's get the party
to
started.
get your
I have a question. So if you're What risk do we have investing in PB if something happens to the company? I don't know who I should talk to. You're both lawyers. What happens if something happens to the business that we invest in?
Well, I mean, the extent to which PE Gate is liable for that, it really depends on what the problem is. I mean, like, it's a reasonable standard of care, and so if something happens in a business, in order to try to impose liability on PE Gate, you'd have to demonstrate that PE Gate breached, a reasonable standard of diligence, and you'd have to look at sort of what disclosure PE Gate provided and whether or not they misrepresented things. Like it would not be easy to pin liability for, a portfolio company blow up on PE Gate. Fortunately for you, and probably your documents are very well known to protect you.
Exactly. So on our offering memorandum, what we take a lot of due care is the risk factors, and they're not made up. So we do disclose, this is not a GIC you're investing in. You could lose all your money. It's actually there. You could lose everything, but your loss is limited to your investment because you're investing in a corp.
So your loss is restricted to the investment?
Yes,
as
because
an individual.
you're investing in a company.
The amount you've invested.
Yeah, and you're a limited partner, so you're not exposed to liability for being in the partnership.
Okay,
Yeah.
that's my question.
And even our structure, although a PE Gate, it's a limited partnership structure, our structure for investments is a corp. It's a corp, so you're limited to that. The corporation is liable, but we don't leave a lot of assets in the corporation anyway, so we distribute that out.
The courts don't tend to apportion liability to directors or management provided it exercise that standard of care. So they won't penalize a director and officer for exercising proper business judgment. So if the directors go through a proper diligence process, get the necessary advice, and it turned out to be not a good decision, absent like negligence or malfeasance, it's unlikely that there would be any liability that would be imposed.
Isn't it different in the US? If you invested in a company in the US as a limited partner, aren't you more liable than you are in Canada? Isn't that true?
The whole limited partnership structure is designed to limit the liability of the LPs. So the general partner is liable for the liability, like for any liabilities of the partnership. And that's sort of a global, and unless that's a global approach, but and on the corporate side, so if you're structuring your vehicle as corporations, you have like the corporate veil. So as a shareholder, you are explicitly, like that's the whole point of a corporation, is to say, look, the directors and officers and managers are doing this stuff. All that we are as passive, we're just passive investors. So.
Yeah. And we're the directors of our holding companies. So I've been through the ICD directors course, and you should get directors insurance. But at the end of the day, if you're taking reasonable care, then you will likely not be liable. Someone could go after you anyway, but it doesn't mean no. So that's why, for example, actually we just had that discussion. So on the pet services business, we overcapitalized, and it was in the OM that we will likely target other acquisitions. So we don't want to go and raise again. So that's disclosed, and we're looking at a transaction. So initially we're going to take it to a vote because we do have in the shareholders agreement, if we're going to raise further capital, then we will go to a 51% vote. Majority of the investors agreed that we do it. In this case, Caroline reminded me, and she's like, well, no, it's in the OM. You actually don't have to go to a vote for that. It's already been disclosed you're going to do
So there's not a raise going to happen within that?
No, it doesn't need a raise because
You got the capital.
we have the capital. It's just, and that transaction is within our mandate that we disclosed in the offering memorandum. We're not going to go buy a food business so with that money. So that's when. But we do disclose to our investors, so we're extremely transparent. We try to be that this is what we're going to do, just so they're aware.
Sorry, I'm asking another question.
No, that's good.
Is that the plan going forward too? Are we going to have more capital than we require on a close for future investments?
It depends. It depends. We've talked about that with Jeff and Leon about confectionery. So we're still trying to decide, do we go after one transaction, or will investors like to see, because we are looking at multiple transactions. So it depends on the situation, but that is a preference when it's a small raise. easier to raise $1 million than it is $200,000.
I think, yeah, it's a good point. Is it a one-off transaction or is it a strategy
Yeah.
to build? And I think one of the benefits of overcapitalizing is you can move fast. And the deal we're looking at right now, they want out in 30 days. And so since we have the capital ready, it allowed us to say, sure.
Yeah, the money's in the
The only
GIC.
pressure's on Caroline, so.
No, us
so
too,
us-
we're still doing due diligence, yeah.
Yeah, so, I think Kate.
A great question though, yes.
So when you're looking at like these smaller businesses and like the pet company or these other smaller businesses, and you have owner operators, I presume, a lot of the time, how do you separate out like, leases versus owner-owned facilities versus like, as PE Gate, are you coming in and looking at buying the business, or are you also buying the real estate? Do you look at like separating that out of the deal, or do you help the current owner look at their structure? What makes sense?
Yes, so to answer that, every deal is different. With John, for example, and Lori, one of our commitments was to remove personal guarantees. So that was important to them. There was no property at the time, but I remember when I first met John, that was the risk to the business that he identifies like, let's buy something, because I don't want to be priced out of rent. And Napanee growing, so that's what we ended up doing after 4 years. So, and then versus other deals, we try to separate out the real estate and we try to make everything at fair market value. So if you're working in a business, you get a fair salary. If we're renting from you, you get a pay, we pay a fair rent to it.
I think we do see it a lot where sometimes the real estate is 5 times the cost of the business, and there's a lot of players in real estate, so we don't want to compete with investing in real estate. So we try and separate it, and then we see a reason why the business does so well is because the owner owns the real estate, and their normalization is a true market value of what the actual rent is. So if you take into account what the fair market rent would be, then the business isn't that the fence deal, right? So it's difficult because,
So we do, we've had another deal where the real estate was a lot more expensive than the business, and that was a deal breaker. They wanted to separate it out, but it didn't make sense for us because it was a risk in the future. Like the equipment they had was specific to that property. You couldn't move that equipment. And if we ever were asked to leave, there goes the business. Like it would be millions to replace and move. That's the
the rent was the lease was expiring in 5 months. Or 4 months.
So we've actually turned down a lot more deals than we've closed, like a lot. And it's these little issues that creep up for us. Yes.
Question probably for Lori. You touched briefly at the outset of the presentation on the fact that there could be conflicts inherent in the business model, PE's business model, and also on the fact that regulators are now coming out with the fact that disclosure is insufficient in certain instances in order to address a conflict or resolve a conflict of investment with the client. Can you elaborate a bit on how within this model steps have been taken to address those conflicts, or how that's been kind of conveyed to regulators?
Sure, well, as Ara would probably proudly tell you, he did a huge analysis of his potential conflicts and in compliance with the new requirements and was very thoughtful about it, and my understanding is has subsequently been audited by the OSC that signed off on his conflicts of interest. But just to sort of, so without commenting specifically on PE Gate, the idea isn't, it still makes sense for these business models to exist because investors have, like Ara and Charmy are bringing expertise to the table. They're bringing investment opportunities and providing, revenue sources, portfolio diversification, all kinds of benefits to the investors. So the question is the compensation that PE Gate is taking for all of what it's bringing to the table justifiable? and that it comes to, even, I'm oversimplifying because it's about more than compensation, but it ultimately kind of comes down to that. Is this really a fair deal for the client? And so that's why disclosure is often a very good solution, because I'm sure that the offering memorandum clearly explains how the profits are going to be allocated and what PE Gate's share is, and the fact that you're structuring, arm's length. Obviously, you're an accountant, but like there's no funny business going on with the financial arrangements between the investors and any third parties where you're kind of moving things off. That, those are all the kind of dishonest things that can be done if you sort of set up an SPV to pull out a part of the business and then don't give access to the investors. So all of those things are conflicts, but they can be managed. And one of the areas I think that's challenging for a PE gate and these types of businesses that are quite unique is that the regulator, when they rolled out this new conflicts of interest regime, they are thinking about like public investment fund securities, mutual funds, the types of products where there are like many available in the market, and that it's very easy to do a market check and to see if the fee structure and the expenses are competitive and are consistent with market standard, or if the product is kind of ripping off the investors. And so one of the obligations that dealers have is there isn't like an obligation to do the market check. There was one at one time in draft, but industry really pushed back on it. But generally speaking, the idea is that RN needs to be comfortable that his proposal is market. Like he's not, he's not charging management fees that are way outside of what is customary. And the experience that RA has for many years, he's been doing this, are really like you're not gonna, like you said, you're not gonna put forward a bad deal.
Yeah, and so they have asked us after our review to disclose clearly on the front page of the offering memorandum, and we repeat it everywhere just so no one misses it. The potential conflict, because we're setting up the SPV, because PGate controls it, and initially we're the director, and then we're going to issue shares. They see that as a potential conflict. There's no other way of doing it. Like, end of the day, it's like, propose a different way of doing it without. So that's a perceived conflict, which we need to disclose and explain how that conflict is mitigated within the document. So first, we also disclose in terms of fees, we haven't marked up any deals. So if we're investing at 100, you're getting it at 100. So that's a big one in terms of fees. So we're not marking it up. So, and it's all disclosed, all our fees are disclosed in there.
And just adding to that and going back to something that you were talking about before, which was sort of like over-capitalizing with a view to making a future investment and disclosing that. One area where I think we need to think about the funding model, because there is a risk if you take investments and the money's sitting in your vehicle and you don't find those opportunities. I mean, it's in a GIC, it's earning returns. So
and then we've actually pushed the money to the operating company. We don't like to hold money in the
So, and then you also run the risk that, so we're on the same page of potentially looking like you're an investment fund, which is a whole other registration category with a lot stricter rules. But so that's why a lot of the times in like the private equity structure, they're sort of like capital calls. So, the investors commit to contribute additional capital when that opportunity comes up, but it's not sort of sitting there in advance.
Yeah.
But it's got to be protected, the money. If it's oversubscribed, and they move it from the LC to the holding company to the OpCo, then that money disappears. Isn't there a problem there?
Well, I think that you can speak to that.
Well, if it disappears, that's where you could sue. Like that's, it should, because we have the banking controls in place. So, if there's fraud, it should not disappear because we control the banking. So, it's like having any money in any portfolio company.
I think what he's just saying is that rather than holding, that investor capital up one level, it's like already within the operating business. So it's, protected by all those safeguards.
Yeah, all the banking signatory rules. And depending on the transaction, we have certain banking rules. So with Kingston, although we own 80%, it's management that operate the bank. But any transaction above 50,000, it would need our signature, for example. In terms of pause, because we own 100%, we control 100% of the banking as PE. And that's where our platform model is. Like, we're here to attract, and I'm so happy everyone came, to attract deal partners. Like Michael's a deal partner, for example. Kurt's brothers are as well. So, and eventually you would bring us deals, which Michael has, and then you'd be responsible for managing that portfolio with us. Because our plan is to grow through partnership that brings deals and helps manage those transactions.
And to go off of that, the Kurtz brothers brought chocolate from a potential deal. So
Chocolate moves,
yes.
so you guys can fight over who gets it at the table.
Is there a little description about it, or it's just an assortment, or
Oh
It's
yeah,
a full assortment.
it's full assortment?
and I've had it all. And it is.
Ara talks a lot about it. I haven't. I didn't go on the tour. That day. It was
It's very good chocolate.
probably. Yeah. Brown.
Maybe just a question on control when you have minority shareholding. So how do you ensure then that, you know, things are happening at that company the way you would like them to happen if you have less than 50% control and board seats and those type of things?
Yeah, generally in the shareholders agreement, we would provide for certain matters that would require minority approval. So things like, related party transactions would require, PEA's approval when they're a minority shareholder. Or if they are doing things that are outside of the ordinary course of business, like expanding the debt capacity. So that way there's always some information flowing back to the minority shareholder, and the minority shareholder can make an informed decision before consenting to those activities by the portfolio company.
And all these governance matters actually adds value to the company. So as a buyer, if that's in place, more people are going to be interested in it. So it's not just from protecting investors, also it is, but also it adds value when you come to an exit.
I think everyone's hungry.
Okay, great.
Yeah.
So feel free to mingle. I think they're going to set up the lunch, but thank you, everyone. Thank you, guys.